Hey guys, it's the end of week 3. I'm going to do a review tomorrow using Big Blue Button, the conference option here. We'll cover everything that is going to be on the midterm, at least generally. I can't give you the answers, but I can tell you what some of the concepts are going to be and tell you how much you need to know. And I will be giving away a lot of answers. I'm just not going to tell you that it's the answers. So you might want to tune in for that. Today I wanted to do a little bit of story time with Officer Frank. We're going to talk about burden of proof. This is on the midterm, so you might want to pay attention to this. And it could serve you well in your life down the road. Okay, so burden of proof basically is just the level of evidence required by the state in order to take any kind of enforcement action, whether it's civil or whether it's criminal. Okay, and so there are 4 of burden of proof. The first one is called reasonable suspicion. The second one is called probable cause. The third one is called the preponderance of the evidence. And the fourth one is called beyond a reasonable doubt. And, sorry. And reasonable suspicion is the lowest burden of proof. In other words, there's a small amount of evidence required to take a small amount of action or some kind of legal interference. Whereas beyond a reasonable doubt is the highest level of burden of proof, and that would be required to get a criminal conviction or to take a significant or substantial amount of legal action against a person. So here's sorry. It's still allergy season. I'm still coughing and probably driving you guys crazy. So anyway, here's the concept. Reasonable suspicion is the amount of proof required, for example, for an officer to make a traffic stop or to temporarily detain somebody for some kind of an investigation. Again, whether it's civil or criminal, not relevant at that point. It's just, and it's described like this: a reasonable person, in this case, a law enforcement officer, a reasonable person has knowledge of some facts or circumstances which indicate that some person may have or may be about to commit some crime. So see, it's very vague. It's not a lot of evidence. But there's some circumstances that are fishy, right? And so under the fishy circumstances, an officer can, they have articulable facts and circumstances. There's a person that may or may not be involved in a crime, but the facts and circumstances suggest that they might be. It's possible. It would be reasonable to be suspicious, hence the name reasonable suspicion. And so they're going to detain that person for a reasonable amount of time investigation, or dismiss it, exonerate the person, right? So that would be, and I'll give an example of all of these, but that's reasonable suspicion. Now, probable cause takes it up a notch. Now it's a reasonable person has knowledge of specific facts and circumstances that a specific person may have been or is being or was about to commit a specific crime. Okay, so it's very similar to reasonable suspicion, but now we've moved up a level from some facts and articulable facts and circumstances that a person may be about to or may have committed a crime. Now we're up a little bit higher. We're saying a specific person. There's reasonable facts and circumstances to suggest that a specific person has committed a specific crime. All right, so both of them require articulable facts and circumstances, but it gets more specific as the burden of proof gets higher. And probable cause is the burden of proof required for an officer to arrest a person. Okay, so there's articulable facts and circumstances that a specific person has committed, is committing, or is about to commit a specific crime. Now I can put handcuffs on you and take you to jail. That's also the same level of burden of proof required for a judge to sign a search warrant that allows the police or the government officials to come into your personal property and obtain or seize your items, right, as pursuant to a criminal investigation. All right, so those are the first two, and then there's preponderance of the evidence, which is kind of out on its own. It equates to, you know, like 51% of the evidence is in favor of one over the other. Okay, so if I were weighing the evidence, and it would be something like 49% to 51%, and then if the plaintiff has 51%, they win. So and that's exactly what it's for. It's for civil court, basically. If I'm going to sue you, it has nothing to do with a crime. It's just breach of contract. You violated a contract or an agreement. I'm going to sue you. If I can present just enough evidence to sway the court that I'm more right than you, then I probably get awarded a victory in that case. This is in Arizona, the same thing that's required for a civil traffic stop, right, or a traffic ticket. If an officer writes you a ticket in Arizona, you're not being charged with a misdemeanor or a felony. It's not a crime. It's just, sorry. It's just a civil infraction. In other words, you have an agreement with the state when you get your driver's license. It's an implied agreement, implied consent, that you're going to follow all the traffic rules. And if you don't, and an officer of the law sees you violating a traffic law, he can write you a ticket, which is basically a fine for a breach of contract. And so you can go to court or you can settle it out of court. It's up to you in Arizona, depending on the type of citation. But typically, let's say it's I'm on patrol and I'm watching a stop sign that's notorious for stop sign runners in a neighborhood. Sorry. So I'm watching, and all of a sudden here comes a couple of women in a car. I'm not picking on girls. This is just an actual thing that happened to me that I'm remembering. And they kind of rolled up into the intersection and slowed down and looked both ways as they were going, and then they just rolled on through. They never came to a complete stop. So I pulled them over and I wrote the driver a ticket. And in the course of the conversation, she goes, "I stopped." I says, "No, you kind of paused a little bit. You slowed down, but you didn't stop, you know." And I wrote her the ticket because it was a high enforcement zone. I usually don't write a lot of tickets, but I did that time. Anyway, she took me to court on it. She went to the judge, and I sat there, and she gave her side of the story. And she said, "You know, in the stop, the officer told me that I paused, which in my mind is a stop." And I told the judge, I said, "Your Honor, I did tell her that she paused, but she never came to a complete stop. Her tires never stopped rolling. That's what I was looking at. So regardless of the fact that I told her she paused and she wants to argue over semantics, the line is her wheels never stopped rolling. That's what I was watching." And who do you think the judge sided with? He sided with me, right? Because I, as a sworn law enforcement officer, I swore to tell the truth, the whole truth, and nothing but the truth, uphold the law, the Constitution, all that stuff. So, you know, they trust me with a badge and a gun. They're going to give me that 1% benefit of the doubt. So if it's just, you know, your word, the driver's word against the officer's word, they're always going to side with the officer. Now, if you can present evidence like a photograph or an eyewitness testimony that contradicts the officer, the judge is more likely going to side with the driver, right? Because at that point there's evidence. But if there's no evidence and it's just your word against his word or her word, the officer is going to win. The state gives the officer 1% preponderance of the evidence just by virtue of being a sworn official. So whether you agree with that or not, whether you think that's fair or not, that's the way it is. And that's how preponderance of the evidence works in the state of Arizona. Now, the final burden of proof is beyond a reasonable doubt, and that's basically them trying to charge somebody with aggravated assault or a DUI or homicide or exploitation of children or rape, you know, something like that. And I'm going to take, if this person's convicted, I'm going to take away their civil liberties to a significant extent, right? We're going to lock them up in a prison and they're not going to get out for a while. Okay, so we're taking away their, so in order to reach that level of legal action, we have to have a burden of proof that is beyond a reasonable doubt. So if I were to break these four things down into percentages, right, I'd say reasonable suspicion, I'll have to be about 10% sure that something fishy is going on, that the person that I'm detaining, for example, is is related to this investigation. I'm 10% sure, right? Probable cause, it's a little higher. It's more like 25, somewhere between 25 and 50%. I'm reasonably sure, 25% or higher, that this person is related specifically to this crime. So sorry. And then preponderance of the evidence, you know, they're breaking a traffic law or something, 51%. I just need to have, you know, 51%. And then beyond a reasonable doubt, it's more like 90, 95%. Like, you have to be really, really sure, you know, and the defense attorney's job in the case of a criminal prosecution, their job is to try to introduce doubt into the jury's mind, because if they can introduce a reasonable doubt in the jury's mind, then the jury can't convict the guy, right? No, you know, there's a reasonable doubt he had an alibi or whatever, you know, then we can't convict him, so he gets off, right? So maybe you're like, geez, you're 89% sure this guy did this. You've got a ton of evidence. You got a ton of proof, but there's like 10, 11% you're not sure. We're starting to get reasonable doubt there. So that's what we're talking about, reasonable doubt. So here's an example. I'm driving my patrol car around late at night. It's 2 o'clock in the morning. I'm on patrol. Officer Frank's answering 911 calls, going to people's houses, driving through the neighborhoods looking for bad guys. You're out of town. You're in Europe with your family. Your house is empty, and it's in my beat. And your burglar alarm goes off, and I get a call from dispatch. There's a burglar alarm at this address in your beat. Go check it out. And so I go, you know, I start slow roll toward the neighborhood. I turn out my lights. I'm driving slowly through the neighborhood looking for anything suspicious. It's 2 o'clock in the morning. And all of a sudden, you know, we're about 5 houses away from your house. And I see a dude running down the street wearing black sweats and a black hoodie. Okay. So it's 2 o'clock in the morning. This guy's out for a jog, and your burglar alarm's going off. Do you want me, Christian, welcome, you're the only other guy here, do you want me to stop and detain this person and ask some questions? So let's see what Christian's response is. Do you have a response, Christian? You just came in. Maybe you missed it, but that would be reasonable suspicion, right? At 2 o'clock in the morning, a dude dressed in black running down the street a couple houses away from a burglar alarm house going off, right? Most people would say, yeah, detain this guy and find out if he's involved. Stop. At least stop him and ask him some questions. The idea is I'm going to detain this person. I'm going to, you know, hit my lights or my air horn and pull up next to him and yell out the window, hey, police, pull over, you know, sit down, stop, whatever. I'm going to go talk to him. Yeah, stop and detain. That's right. Christian says stop and detain. He's absolutely right. So I'm going to go talk to this guy, right? Is it possible? I mean, do we know for a fact that this guy is doing anything other than going out for a jog? We don't. But under the circumstances, right, when we go back to talking about reasonable suspicion, a reasonable person has articulable facts and circumstances that a person might be involved in a crime, right? So the burglar alarm's going off. Is there possibly a crime there? Breaking an entry, burglary, whatever. Yep. We have a person here, a jogger down the street at 2 o'clock in the morning wearing a black hoodie. That's reasonable suspicion. It meets the requirement. I stop him. I start asking him some questions. He says, hey, man, I don't know what's going on. What do you want? And I said, well, you know, there's a burglar alarm going down here. Where'd you come from? Get some information from him. And another officer, I get on the air and I say, hey, I need backup. I'm out with a subject. I need another officer to go to this address and check on the house. So another officer rolls by, goes to the house. I'm sitting there making small talk with the jogger, and another officer gets to see and says, yeah, it looks like we've got signs of a break-in. There's broken glass by the front door. It looks like the door's been open. It's not locked. Looks like there's a little bit of blood on the glass, and there's some muddy footprints here in the drive on the sidewalk, right? So I say to the guy, I say, hey, let me see your hand. So he pulls his hands out and he's got his hand wrapped up in a handkerchief. And I say, why is your hand wrapped up in a handkerchief? He says, I was running and I tripped and fell, and I scuffed my knee and I skinned my hand a little bit and it's bleeding. I just wrapped it up in this handkerchief. Okay. So, suspicious, right? Are we building evidence. Yeah, our suspicion is going from reasonable suspicion to probable cause. It's getting higher because now there's blood at the scene and he's got a bloody hand, right? I say, okay, why don't you turn out your pockets for me? He turns out his pockets and he's got a screwdriver, right? And a wallet. Okay. So what's a screwdriver for, you know? And he says, well, I was running over to my friend's house the other night and we were fixing something and I just left it in my pocket. I don't know, you know. So the officer at the scene says, yeah, it looks like there's also some scuff marks around the door jamb, like somebody was trying to jimmy the lock or something. So, okay, we've got blood, we've got a screwdriver, a possible burglary tool, we've got scuff marks around the door, we've got broken glass. And then at the last, he says, you know what, we've got, it looks like some size 9 Adidas here, muddy footprints by the front door. You know, we don't know what brand they are, whatever. They've got size 9 footprints. And I look at this guy and he's got muddy shoes with, you know, about that size tennis shoe. I say, okay, now we've got what I would consider probable cause. What can I do at that point? You know, if it's your house that got broken into and this dude's running down the street with that level of evidence, do we arrest the guy? What do you think, Christian? Is Christian still the only one? Yo, Jackson's here. Jackson, what do you say? Do we arrest the guy yet, or do we keep looking for more evidence? Nobody wants to venture a guess. At that point, okay, so Christian says, yep, arrest him. And I would agree with Christian. Yes, arrest this guy, right? Do we know that he's guilty? Maybe, you know, maybe his story is true. Maybe it's all circumstantial at this point, right? We don't know that that's his blood. We don't know why he had the screwdriver. Maybe he has a good excuse for it. We don't know if the shoes match the muddy prints on the sidewalk up there. But we have probable cause. Now we're starting to put facts together that this guy looks like, you know, he's, you know, so I'm maybe before I arrest him, I'll ask him a few more questions. Hey, where'd you say you're from? Where's your house? Oh, okay. Well, do you have any ID on you? Oh, is this your wallet? Oh, wait, you're not from this part of town. Where are you from? Oh, it says you're from Tempe. Oh, that's an old address. So you do have a house around the corner? Oh, you do? Let's go to your house. Oh, it's not your house. Oh, so you do live in Tempe, right? So you know what so you start, now we're going, okay, this is starting to very fishy. You can kind of got probable cause. We're going to hook this guy up. We're going to give him a pair of nice silver bracelets behind the back and put him in the back of the patrol car and take him down to the station and book him. Now, is there some more stuff that we need to do before he goes to trial? Absolutely. There's a ton of stuff. This guy's not going to, we're not going to be able to put this guy in prison or in jail or get a conviction at this point because there's too much reasonable doubt. A jury and a good defense attorney is going to get this guy off the hook in a heartbeat, right? Because we don't know. So as the detective, as the investigator, we got a lot of work to do. We got to go to the scene of the crime, start looking for video surveillance footage, maybe test the blood, right? Test the DNA, get a DNA swab off of this guy and test the DNA, look for fingerprints, do you know, some crime scene photography and check the footprints and compare it to his shoes. We're going to impound his shoes. We're going to take pictures. We're going to all that trace evidence, right? So at that point, we start building a case that, yep, the shoes match, the DNA matches. Yeah, his fingerprints are at the scene of the crime. He's not from there. All that stuff now we've got beyond a reasonable doubt, probably going to get a conviction if all of that stuff is true. If any of that stuff's not true and it's just circumstantial, then a good defense attorney could get him off the hook, and rightly so, right? So that's the way the justice system in the good old United States of America works. It is more or less stacked in favor of the accused, which is the way it should be, right? You know, you'll hear cops and conservative-minded people, they'll complain about how bad guys get off the hook all the time, you know, the damn liberals and all this stuff. And I just laugh. I'm like, you people are idiots. It's supposed to be that way, right? The cop's job is supposed to be hard. It's hard. It's supposed to be hard to put people in jail in America. And that's great. That makes being a cop fun. It keeps them honest and it protects the innocent people, right? Do guilty people get off the hook sometimes? Absolutely, right? Occasionally we know innocent people go to prison. Yeah, and that's right. Christian, innocent until proven guilty. That's the theory. It works most of the time, at least better than most other judicial systems in the world. This one works pretty good. Like I said, occasionally we will get somebody that goes to jail innocent, but more often than not, it's actually the guilty that get off the hook. And that's the society I want to live in. That's the society I want to be a cop in. I don't want to be a cop anymore. That's why I retired. But you get my point. That's so these four burden of proof concepts: reasonable suspicion, probable cause, preponderance of the evidence, and beyond a reasonable doubt, will be on the midterm. I want you to kind of get a concept of what that means in terms of digital forensics, right? Now, reasonable suspicion, that's to stop and detain somebody. Don't know that it really applies too much to digital forensics, but probable cause, if you're investigating an internet related crime, do you have enough probable cause, enough specific facts and circumstances to tie a specific person or a specific IP address to a specific crime? You have to write that up in your search warrant, and then the judge will sign it if it's valid, right? If you have sufficient probable cause. And then the search warrant, you kick in the guy's door, you go and you take his computer and you take his, his smartphone, his tablet, all of his digital evidence, and then you go back to the lab and you process it to get down into the dirt and get into the nitty gritty and find, rule out any reasonable doubt by getting good criminal evidence off of digital evidence off of his hard drive, for example. So you guys did a lab this week on going in and looking at an image of a computer that was supposedly used for creating false images, and you guys did a great job, looking at forged driver's licenses and things like that. So you get a little bit of an idea of what it's like to do some computer forensics, kind of a fun lab. Any questions? I'm going to wrap it up and cut it short tonight. I just wanted to cover burden of proof concepts here tonight. Tomorrow we'll go over the midterm and at least, not go over the midterm, do a little review of the midterm. Do you have any questions tonight before I go to bed? I got to get up at like 4 o'clock in the morning. I got a service problem tomorrow morning. So Jackson, Christian, you guys got any questions from this week, or this is end of week 3? Anything leading up? Okay, Christian's good. Jackson, you got anything? If not, I'm going to bed. I will tune in tomorrow. Dominic, welcome. You're just in time. Just in time for the very end, but I did record this, and I'm going to post it under the announcements, and under conference it'll pop up, so there'll be a link to this video within a few minutes usually. Jackson just joined, no problem. You didn't miss, you missed, the first half. So not a long video lecture here tonight, but Dominic, you just joined us. You missed the lecture, but I'm doing a Q&A right now if you have any questions before we break for the night. And we're going to do a midterm review tomorrow, probably around 3 or 4 in the afternoon. Again, I'll video record it. And if you're not able to watch it in the afternoon, you can watch it sometime tomorrow night or Saturday. The midterm will be available to take anytime starting at midnight Saturday night, or early Sunday morning, all the way to Monday at midnight. So that's is the midterm multiple choice or short answer? It was short answer. I changed it. I went in and made it 50 multiple choice questions. I'm not trying to trick you on any of them. As long as you know your stuff, there's 4 possible answers. I think there's only one question that even has all of the above as a possible answer. So anyway, I'm not trying to trick you. It's just 50 questions on a lot of stuff we've covered. Good question. Any other questions? I made the questions. One of the problems we had with this course before I came in was that all of the quizzes and the tests were taken exactly from the book. In fact, they were taken from the review questions of the book, and all of the answers were available online. That's why we don't have any quizzes for the weekly. It's just the midterm and the test. So I made the questions, but they are related to the reading, mostly to lectures, to the labs that you've done, and to some of the homework assignments you've done. Good question. Other questions? Never hurts to read the book, though, Dom. Read the book because it covers most of the stuff on the midterm is covered in the book. And if it's not, it's definitely covered in the lectures. Tune in tomorrow at 3 or 4 in the afternoon if you can. If not, again, I will record the conference, the review tomorrow, so that you'll be able to watch it at your leisure before taking the midterm. All right. Sorry for my coughing. It's allergy season, and got this horrible dry tickle. Well, you guys, it's late. I'm an old man. I'm going to go to bed. Like I said, I got to get up about 4 in the morning. So that's it. That's all I got. Are we done? No more questions? All right. Adios, amigos. Have a good night.